The federal government opened a registration portal on April 29th. State licensed cannabis operators have 60 days to file. The DEA reminds you in bold that lying on this form carries up to 4 years in federal prison and a $250,000 fine. Answer the question honestly, and they require you to answer it honestly. You are confessing in writing to federal drug trafficking. Confess to a federal crime or commit a federal crime. That is what this form says. I'm Patrick Nolan. Today on Pat Talks Law, what's actually inside the DEA's Schedule 3 application and why operators are calling counsel before they touch the submit button. Quick context. On April 23rd, Acting U.S. Attorney General Todd Blanche signed an order rescheduling FDA-approved cannabis products and state-licensed medical cannabis from Schedule 1 to Schedule 3 of the Controlled Substances Act. He cited authority under the United Nations Single Convention on Narcotic Drugs. 6 days later, the DEA's Diversion Control Division opened the dispensary application portal. State licensed medical operators have until June 26th to file for the expedited review window, 6 months to a yes or no, after which the federal government must grant the registration, unless doing so would be inconsistent with public interest under 21 U.S. Code Section 823. Filing fee $794, non refundable, ACH or PayPal. The portal for manufacturers and distributors, the people who actually grow, process, and move product, has not been clarified yet. That's the front of the form. The trap is in the middle of it. Quick break. If this is the kind of legal news you want in your feed, hit subscribe and like the video so YouTube pushes it to other operators making this call right now. Back to the application. The application is 7 sections. The liability section has 5 questions. 2 of them are the issue. The first one, quote, has anyone who will be involved in the ownership or operation of the firm previously manufactured, distributed, or dispensed any controlled substance without a DEA registration authorizing such activity? End quote. Every state licensed cannabis operator's honest answer to that question is yes. It has to be. There was no DEA registration available for cannabis until April 29th. By definition, every dispensary in this country has dispensed a controlled substance without a DEA registration. That's the entire industry. Now, the activity section, quote, will your firm be handling or dispensing recreational marijuana? End quote. Recreational marijuana is still federally Schedule 1. Schedule 3 only covers medical. So if you answer yes, you have just told the federal government on a federal form that you are trafficking a Schedule 1 controlled substance. Trulieve, the multi state operators, every operator in a dual use state has to think hard about how to answer that question. The DEA's submission warning page reminds applicants intentional misrepresentation on this form is punishable by up to 4 years in federal prison, a $250,000 fine, or both. There is no third box. There is no it depends. You either answer the questions or you don't submit. And if you don't submit by June 26th, you don't get the expedited review. So why is anyone filing? Jason Adelstone, an attorney with Harris Slavowski, called the registration a calculated bet. His argument is this: early filers position themselves for first mover advantage if Schedule 3 becomes the gateway to a federally recognized and potentially global medical cannabis market. Future interstate trade, future export licenses, banking relationships that today are restricted or refused, mergers and acquisitions clearance, exchange listings, Adelstone's number for legal fees on a properly prepared application is $10,000 to $15,000 before complexity adjustments. He estimates the upside at hundreds of thousands to millions of dollars per registered entity if the federal market opens up. Trulieve didn't wait. The day the portal opened, the company filed. CEO Kim Rivers called it a historic step forward. Trulieve operates more than 200 medical only dispensaries. About 85% of its national footprint by store count is medical, which materially reduces the disclosure exposure on that recreational marijuana question. The law firm Foley Hoag broke the upside into three buckets. One, potential access to export licenses. Two, interstate commerce if and when federal or state law permits it. Three, a compliance prerequisite for banking, exchange listing, credit facilities, and mergers and acquisitions. That last one is the real driver. A federally registered medical cannabis company is a different animal in a deal room than a state licensed operator running on cash. The cost of being early is the disclosure itself. Whatever an operator puts on this form lives in a federal database. If the political landscape shifts, the disclosure does not disappear. And it has shifted before with this industry. Here is the timing problem. The 60-day window for medical operators to file for expedited review closes June 26th. 3 days later, on June 29th, the Department of Justice begins a separate, broader administrative hearing. That hearing debates the merits of the same Schedule 3 rescheduling rule that was issued under the Biden administration. It concludes no later than July 15th, 2026. Read that sequence again. Operators filing for expedited registration submit before the federal government decides whether broader rescheduling, including adult use, actually goes through. They are betting on the outcome of a hearing they cannot see, with a disclosure that lives forever. Dual use operators have it the hardest. Companies running both medical and adult use facilities in legal states. The federal form pushes them to acknowledge an activity that under federal law is still a felony. Bottom line, if you are a state licensed cannabis operator considering this filing, this is not a form to fill out yourself. The questions are simple. The answers carry permanent federal consequences. Talk to counsel who has filed Schedule 3 registrations or controlled substance disclosures before. Ask them specifically how they would document the recreational marijuana question for your operation. I'm Patrick Nolan. This is Pat Talks Law. If this kind of legal news belongs in your feed, like the video, subscribe and share it with anyone in the industry making the same call right now. There will be more on this between now and June 26th.